The Supreme Court hearing arguments in a landmark case that defines how content platforms handle user content. At stake, how much platforms can moderate users' posts and whether they should be held accountable. Supreme Court justices so far appeared split on the issue as Google presented arguments. Yahoo Finance's Alexis Keenan was there at the Supreme Court yesterday.
Got to see the action,
yeah. Tell us about it.
So that was one of two cases the Supreme Court is hearing yesterday and today, and they both are near mirror images of each other. In both of these suits, they challenge Section 230 of the Communications Decency Act. It's a 1996 law that shields what's called interactive computer services, and what we think of there as social media and other platforms that allow third parties to exchange information, make comments, and socialize. That's what these cases are about. What that law does, it keeps the companies that are the platforms immune from being held liable for what other people say on their platforms. So both of these cases, they arise from ISIS terrorist attacks. The plaintiffs here, they are victims, the estates of victims suing Google, suing Twitter, suing Facebook, saying that these companies should be stripped of their 230 immunity in certain cases. And they say that's because they shared and promoted videos, content to ISIS sympathizers that then led to these attacks. Now, one of the cases, that was yesterday's case against Google, and in this case, YouTube is the one being sued here. The plaintiffs said that they should lose their immunity in that case because YouTube's algorithm recommended content to the people who eventually watched these videos and sympathized with ISIS. Now, the other case that's being heard today, that one is against Twitter, Facebook, and Google collectively. They say that in that case, 230 shouldn't apply and the immunity should be stripped because the companies failed to block harmful content, that is. So in both cases, they're saying that these videos or these shares of social media that this is other people's voices, what other people said, that if these companies amplify it and they promote it, they put it at the top of search, for example, that's the thing that should separate whether there's a recommendation being involved or whether it's just purely a neutral kind of serving of information when a search is performed. Google's position is that there's no way to draw a line here, right? You can't draw a line between a company attempting to sort and actually what is a recommendation. They say if Congress wants to change Section 230, that is their purview. It should not be before the Supreme Court.
The Supreme Court yesterday, if you read a little bit, and of course you were there, about like the justices questioning, they seem to be really zeroing in on little technical parts, like was it in a thumbnail that they were recommending stuff? Like, is that stuff going to be really pivotal eventually?
It may be. It was highly technical. And keep in mind that in the Google YouTube case, the plaintiff's argument, and the Biden administration is also making arguments in this case that 230 should be narrowed for a little bit of a different reason. But the thumbnail issue is part of an evolving argument on behalf of the plaintiffs. And the reason is it's because it's so difficult to decide where is that gray line. And so they decided that, well, it's when Google or YouTube generates a thumbnail, and now that's Google, YouTube speaking. That's not the third party speaking anymore. They are generating content, they're amplifying, they're serving it up to users, and they say that is where the line should be. The justices not necessarily buying that from both sides of the aisle. They were challenging
this. It seems like the algorithm is that already. The algorithm is something that YouTube generates. Anyway, go ahead, Bruce.
Well, no, it just begs the question of what material changes then these platforms would have to make and how that would so disrupt the user experience that is already present that they've been able to monetize to this point as well.
Right. So one of the plaintiffs' contention is that the internet has changed, that the model is now an advertising-based model, and that's what's causing these companies to boost up videos that are harmful, whether they're third party speaking or not. So that is something that is a very difficult challenge, but look, these two cases, they absolutely could make sweeping overhauls to the internet and the liability. And if you just look at Google's 2022 ad revenue alone, almost $225 billion. Carve out YouTube there, you have $29.24 billion for 2022. These are major stakes in both of these cases that we will be closely watching.
Yahoo Finance's own Alexis Keenan really teeing this up and tracking this boots on the ground at the Supreme Court. Thanks so much for keeping tabs on this.